Asylum seeker and refugee. Burden of proof. According to the UNHCR Handbook, para 196, while the burden of proof in principle rests on the applicant, the duty to ascertain and evaluate all the relevant facts is shared between the applicant and the examiner. Indeed, in some cases, it may be for the examiner to use all the means at his disposal to produce the necessary evidence in support of the application. Even such independent research may not, however, always be successful, and there may also be statements that are not susceptible of proof. In such cases, if the applicant's account appears credible, he should, unless there are good reasons to the contrary, be given the benefit of the doubt. Status determination should begin with the presumption that the claimant is telling the truth. Con. F. and Scheier. T. Refugee Law in South Africa, Juta. 2014-41. There is a subjective and objective component to a well-founded fear. Delayed application. In Abore, the Constitutional Court found that a delay by an undocumented immigrant in applying for refugee status does not affect their right to apply for recognition as a refugee.
Any delay in applying for refugee status is only relevant to determine whether someone is a genuine refugee.
But it should at no stage function as an absolute disqualification from initiating the asylum application process. An undocumented person who seeks refugee status can only be deported after their application is rejected. Interpreter, on applicant's account, and this is the only version before the court. He did not enjoy the hearing to which he was entitled in terms of the relevant provisions of the Refugees Act, the regulations framed pursuant thereto, and the provisions of the Constitution. This is essentially saying he had no interpreter,